Testing the proposition of whether the senior administration lawyers could, in theory, be criminally responsible for their actions in authorizing interrogation techniques that may amount to war crimes obviously goes beyond the scope of what I can talk about today. So let me just cut to the chase and share with you the conversation I had with a European judge and a European prosecutor. In the book, I go into some detail about this conversation. I've anonymized these two individuals for obvious reasons. I visited with them in the capital city of a European NATO member state. I laid out all of the materials that I'd come across, everything I've talked about today, and a great deal more that I've written about in the book. And I asked them, in your system of law, criminal law, in accordance with the applicable international norms, is there any basis for investigating these lawyers for international crimes? And we looked in particular at Article 4 of the Torture Convention, which criminalizes complicity or participation in torture. And similar principles, indeed, govern the acts of accessories to violations of the standards reflected in Common Article 3 of the Geneva Conventions. And the European judge and the European prosecutor were particularly struck by the provisions that I directed their attention to in the Military Commissions Act of 2006, the purported immunity provisions. The prosecutor said the inclusion of such a provision in the Military Commissions Act was a very stupid thing to do, because it would make it much easier for investigators outside the US to justify their own investigations, since it was plain that war crimes allegations would not be investigated in the United States. If President Bush is sensible, he will reflect on this in deciding how to proceed in the idea that is now being mooted of granting a general pardon to anyone who is involved in all of this. This is one of the tripwires for enabling foreign prosecutors or foreign judges to intervene. It's a matter of time, the European judge said to me. These things take time, and then something unexpected happens when one of these lawyers travels to the wrong place. This judge and this prosecutor, who I can tell you are experienced in the prosecution of international crimes, had no doubt whatsoever, that on the basis of the facts laid out before them, the clear involvement of senior administration lawyers in the decision-making process could give rise, at the very least, to a basis for investigating accessory involvement in war crimes. In our system of government, in Britain, in the United States, in constitutional democracies around the world, the lawyers are guardians of legality. Many of us act for governments, I do on a daily basis, or other clients who ask us to advise or sign off on things that may raise concerns. We ask ourselves, what are the limits of what we can do? Our responsibility is not only to our client, it extends beyond that to the system of justice and to the rule of law that underpins our system. That is who we are. If we cross a line, if we rubber stamp a policy that has already been predetermined, if we act on an invitation to give advice where it is known or likely that we will merely provide the advice that our client wants, then we risk crossing the line that separates good advice from bad advice from unprofessional advice, and unprofessional advice from advice that can allow a crime to occur. On the basis of the materials that have already emerged, including those which have emerged in numerous congressional hearings that have happened over the course of this year, it seems to me there may be a good basis for some sort of investigation. This is not because the actions of the lawyers discussed in Torture Team are in any way analogous to those associated with the defendant lawyers in the justice trials or in the film Judgment at Nuremberg, but rather because their actions associated them very directly with acts that violate standards set forth in norms of international law that were put in place in the aftermath of the Second World War, put in place largely at the instance of this country, which has led the world in a rule of law ethic and which has a vital importance on that issue. These are norms that provided minimum rights for all detainees and admitted of no possible exceptions. Even if those most responsible for these actions are placed at the political level, even at the very highest levels of the administration, their lawyers were enablers. It was they who furnished the legal weapons that allowed the acts to occur. But for the lawyers, the 15 techniques used on detainee 063 would never have seen the light of day. How easily it can happen, said Spencer Tracy's character, foreseeing a time when even in the United States there would be those who would speak of the protection of country, of survival, to justify using the means of the enemy to wrest survival upon what is expedient. Thank you very much.